בדיוק איפה אז זה גם כאילו
תרגישו חופשי להתחיל לאכול, לחלק, להזיז דברים אינסופיים.
בול שם. בול שם. כן.
Okay, we promised English, so it's going to be in English. Anybody here doesn't speak Hebrew? Doesn't speak Hebrew. Anyone here? No. So everybody speaks Hebrew?
Yes.
Yeah. So it's just for my fun, the English part, and for the broadcast, hopefully it's people will see. I have no problem with that, assuming that none here is a student and none of the teacher in English. But okay, so we'll just publish the fact that we are live and then move forward. How do you get eating pizza? You can start eating the pizza. It's allowed.
אני לא יודעת מה שקורה. זהו, זה גבינה מקרות מרגריטה, זה לא... לא, בשביל שלדע כיף יכולה לחלק את האפלטונים.
כי לקחה לעצמה.
לא,
תראי, יש לך למגש, את הקרטונים רק...
אז יכולים כל הפגש על
So least you could do. יש לך עוד קרטון? I know where you live.
רגע,
זה יצא ממש קטן. פיצה כל השבוע לא אכלתי לחם, אני באמת אותך נאמן שלי. ברור, נדעתי המחגים. באמת, יום כיפור ניצה מלכת הכנסת. זה לא במלכה שאני רוצה לראות כמה שאני אומרת, לספר לחברה נוראית שלי שתעבור בתשובה ויש אותי שהילדים בבני
נכון, אני יותר אוהבת צ'יזבוקר.
מה, לא? אני אוהבת צ'יזבוקר?
אמרתי, נדעתי על החגים. לא, יותר טוב, חברה שלי באה מבית דתי, אבל אז היא כן מכירה מחשב והכל, היא פשוט לא תכתוב בעצם, לפי מחשב. מנתן גאיון, ואז מסתבר שבאתי לצחוק על זה עם חיילים שלי, הייתי בצבא, צחקתי, ואז אני כזה, יואו, אתם חושבים, יש חברה הזאת, תדעים את זה ואז חיילים שעשה לי, גם אני ככה. היא כזה, מבין. גם אני כמה מתמתמת.
אני חושבת לך שפרה את זה בלייב. על זה?
לא, לא על זה. לא, על זה כזה קיימת.
מה עשית כאן?
לא סידרתי לה בית החייל. כי זה ממש שודי שיש תור של 4 חודשים בבית החייל. והיא לא רצתה לישון בבסיס. כן, רוצה לדחוק את המסתיים. לא, לא. בסדר.
Okay. Welcome and thank you for coming for this session. We're trying to keep the forum sessions on 2 types of levels. One is general lectures on recent developments and recent updates in the field, and the other type is current events. So this session is clearly an issue, is focused on current events. current events in Syria, which I think most of you are familiar with and heard about recent developments. And there are some questions that come up out of these recent events. And the purpose of this session, and here we're trying to give you a concept of our sessions. The purpose of this session is to make a new type of session, which we call it pizza in IHL. The pizza is to bring you here, the IHL is to keep you. And it's not going to be me talking now for 1 hour or something like that, talking about different issues. It's going to be more of a discussion, questions, and roundtable discussion on what happened, what are the issues that are interesting to see out of it, and what can we know and what we don't know about these recent developments about Syria. So if we're going to start and map things out, the two main developments that have reached the public's opinion are the use of chemical weapons in Syria, and the other one is the American response to that. Now, there are other issues to be taken care of, to think about, like the fact that there was already some kind of discussion in the Security Council on the situation. There has been an agreement between Assad and at least the US about removing and destroying chemical weapons in Syria, and all of these points could have an effect, and perhaps should have an effect on how we look at it and how we analyze the situation. So let's start with a round introduction, so we know who's here, and if you want what interests you in the situation in Syria right now. So let's start with
So my name is Ran, 27 years old. I'm a student for law and government here at IDC, 4th year, about to finish. Next year I will be interning at the Deputy State Attorney's Office for National Security Matters. I think that's the best English term I can find for it. And I'm also the IHL and ICL clinic coordinator here at IDC. And I think that's all.
My name is Jonathan, I'm 32, and I'm a German attorney originally. When I moved to Israel, and I interned with the Deputy Attorney General's Office for International Law, and now I do private legal work, and I'm also a member of the Center of Applied Negotiations at the INSS think tank in Tel Aviv. And you asked what's interested in the discussion. So when I think about Syria and IHL, I'd be very much interested in the developments on the conflict qualification, and also in the gap between how states view these recent attack by the US and how the blogs have responded to it. Because when I looked at the blogs, I sort of criticism, which I didn't find always convincing, and I see the response by leaders, it's very, very different. So thanks, so I came today to hear what you think about this. Yeah.
Jonathan, studying here at Land Governments here.
Sagi, study also on government second year.
I'm Drora. I have a PhD in International Comparative Law. I teach law and terrorism at the School of Government. I think, I don't know if we'll reach it, but I think an interesting question is the Russian role within the chemical weapons attack, because you see a lot of information coming out that Assad wouldn't do this without, some sort of, let's say, turn a blind eye by the Russians, and that's actually something that hasn't really been discussed in this whole issue. Is Russia now, responsible? Are they compliant? What's their role? What does it mean legally?
Ella, second year of law and business.
Tamar, I'm also second year law and government. I think it also be interesting to talk about not only the attack itself, the American attack itself, but also the legal implications of that going forward. As there are a lot of the news outlets that have talked about how this is only the first of many or more possible involvement. It is this also changing the classification of the conflict, but moreover, is it vaccine? Is it's maybe intensifying or even causing more problems that it essentially tried to solve.
I'm John. I'm also second year law and government.
Susie, first year law and government.
I'm Cal, first year law and government.
First year law and government.
I'm glad we are starting to, I want to say something. Sorry. Okay.
So I wanted to say that I think what interests me is the aspect of the internal issues that have brought the American attack. Is this a game changer? I mean, until now we saw a very different policy.
The reason the U.S. policy?
And how maybe we're looking at. And also, so I work with UNDOF, the UN Force, and the question is also the different reactions different countries have, and the reasons, their interests and agendas, and why they react with.
My name is Yuval. I'm studying together with them, so I'm first year in my government as well, of course. I think one of the most interesting points for me is that, like, what's the difference between using chemical weapon and between using chemical weapon and not using chemical weapon in relation to the response of the US. You understand what I'm trying to say? Yeah. Like why using chemical weapon? It's like a red line for the US to react to those kind of actions.
Hi, I'm Maya. I'm first year law and government. For me, in relation to humanitarian and the chemical weapon, I think what interests me is what was the motive behind the American response. Because I've heard some claims that it's actually not really a game changer. It didn't really influence, I don't know, say better, but it's a claim that I heard that it didn't practically influence a lot of the battles. And was it more of like a טיפול לכאורה? I'm not trying to say it. Yeah.
My name is Lou. I'm the chairman of ALMA. I'm also director of research at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa. And I'm doing a PhD at the University of Jerusalem about humanitarian law, human rights law, international law. There are a lot of issues here. All of them are actually internal American strategy, politics, which are interesting. I'm not sure I'm the biggest expert on anything, but let alone on internal US issues. So everything is going to be discussed around this table. It's basically personal opinions and anything goes, any opinion, and I'm going to try to moderate the discussion and present my point of view on certain issues, but around the table, I'm sure there are enough opinions on different issues that are more clear to listening to, and the more discussion we're going to have, the more interesting it's going to get. So let's start with the beginning. We have an armed conflict going on in Syria. an armed conflict between the government, and you can't really say rebel groups because you have several groups there that are either organized, less organized, working together, working against each other. You have questions of ISIS there, you have questions of local Syrian resistance, and when the question on the classification of that conflict comes into play, are we talking about international conflict or non-international conflict, which has some implications on what is allowed and what is not allowed to do in the battlefield and provides legitimacy to external players to play around. It's safe to say, I think, that the general opinion is that we're looking at some kind of non-international conflict, some kind of civil war, which is mainly internal between the government and the armed groups. Now, we know that there are external players in the game. We've seen some attacks from Turkey in the border in Syria. We've seen some attacks from Russia in cooperation with Assad. And we've seen the attacks from the US against the government in response to an attack, the use of chemical weapons. Each one of these players could be relevant to the question of what is the type of conflict. Do we have an international conflict between states now? Or are we still within a limited, geographically limited civil war and no international conflict in the professional term? And we need to look at it differently. So the easiest way is to look at Russia. Russia is operating at the request of Assad, which under international law means that they are allowed to and they don't change anything within the framework. It's still the government using the help of Russia against the rebels. And when we look what Russia is doing, they are using fire, they are providing equipment, they are training, they are very much involved in the conflict to the level that they feel comfortable with. Would that change anything within the conflict? Legally, no. Legally, basically, when you have the government asking the help of another government in a non-international conflict, an internal conflict, the situation remains the same. So let's move a bit. We can't move anywhere from Russia to Turkey over Turkey, so let's move from Syria a bit south to Turkey. We have the border between Syria and Turkey. And we've seen some attacks between Turkey and within the territory of Syria. Some of it was against rebels, some of it was against the government, most of it was, as far as I know, against the government. And this could raise the question of what now? We have two armed conflicts, one between Assad and the rebels, and one between Assad and Turkey, the government of Turkey, Syria as a state, and Turkey, or are we looking at the entire framework as one framework, saying that Turkey has just got involved in an international conflict which has 3+ players to it, which make things very complicated on classification of conflict, applicable of who's against who, and what are you allowed to do and not allowed to do, thinking about people crossing the border from Syria to Turkey. Are they now citizens of the enemy? Are they allowed to receive treatment? Are you allowed to deny treatment? And that's another spectrum of questions. But if we look at the situation, one can also argue that there is no armed conflict that Turkey is involved with. These are just protection of the border. And if we look at, well, some of you might have heard of the oil platform case of the ICJ, where they say that cross-border incursions don't amount to an armed attack. So if you could argue that Turkey just protected its border, then one could argue that Turkey is not involved in this armed conflict, and there is no armed conflict related to Turkey. They're just operating on an ongoing basis with regard to the necessity to protect the border.
Can we ask that?
Yes. Discussion.
What about the assistance that Israel is providing the government's medical assistance? It's ongoing for a few years. Is it recognized as intervention in this conflict? Is it international intervention or just, I don't know how to classify it?
Okay. Hopefully if someone else has something to say, it's okay, because I can't answer, but I would rather hear a discussion. Israel has a moral and legal obligation to take care of anyone who comes into its territory, anyone injured, and taking care of that person to at least the minimum extent needed. It doesn't mean you're intervening in the conflict. If you're actually getting into the border, getting into fighting, that's something else. But just providing humanitarian assistance and medical treatment is not considered as intervening in the conflict. Unlike when we said earlier, Turkey, there is a question because they actually use firearms. US, there is a question because they use firearms. Russia are involved in a certain way because they are supporting the government. But Israel, with regard to humanitarian aid, is medical aid, and is not an intervention in the conflict.
What is the origin and the extent of the legal obligation? Because they're not crossing into a territory. We're opening up the fence and taking pictures.
Well,
we're not just opening, we are calling
Yeah.
with them, with the rebels.
Right. So obviously morally I understand, but legally.
well, it's not a Geneva Convention clause, but as long as you have the ability under human rights to take care of someone, you have the responsibility under international law to help that person. If you have the ability to prevent humanitarian crisis or to help a person, you're supposed to, because that person is either internal displaced person or refugee once he crosses the border from the conflict zone. So if that person has crossed the border from the conflict zone, he become a refugee, he is under the Refugee Convention. And whether or not you will grant him refugee, if he is an asylum seeker or something like that, you would be under some level of obligation under either customary law or under treaty law, depends what that person's status is, to provide medical aid.
But one may say that we are treating them in order to help them to keep on fighting. We want them to be able.
I have no idea about the amount of people that we are treating. I really doubt about the effect of the amount of people we are treating on the conflict zone. I mean, to argue that if you're even treating 1,000 people a month, I don't think, I doubt if we're getting into these numbers. I have no information about that. I doubt if we're getting into that amount of people we are treating, because you actually would see this kind of transfer from Israel and Syria. It would be visible. It still wouldn't be a significant increase in the numbers taken care of. People are dying in these amounts in Syria. So,
Is there some sort of legal framework that frames the classification of refugees? Because, for example, in the Rwandan genocide, so the perpetrators of the genocide then crossed into Congo and were protected as refugees, even though you could argue that they're criminals and shouldn't be protected under that clause.
Okay. You're a refugee.
What's the question again?
The question is if there's any legal,
Any
document that
legal
deals with
obligations?
classification of who,
Or refugee.
Refugee convention, it's customary.
right,
So-
it doesn't really.
Because not every refugee of war is actually considered as a refugee under the Refugees Convention, because he must, the one that argued that he is a refugee, he or she is a refugee, must prove that he was persecuted by his government, and not only then he can ask for refugee status. But from the hosting state, from the behalf of the hosting state, when they are hosting people that are claimed by other states to perpetrate a war crime or participate in illegal acts. So I think there's a rule. I don't know what is the basis of this rule, but it's called Moderator or judicature, something like that. That means that it's, you either extradite him to a country that will put him in trial, or you put him on trial yourself.
So theoretically, if Syria came to Israel and said one of the refugees that is sitting in the hospital right now is committed a war crime, we would have to either put him on trial or something.
They could argue that. I think there was maybe a Syrian person that was on his way to Israel that was claimed to commit war crimes in Chile or some other country in South America, and there was debate on whether Israel should extradite him, but eventually he didn't come to Israel at all. And so the question didn't come up eventually.
He didn't show up because we told him he's not allowed to show up.
Well, that is.
Okay, so let's frame the question. The question was, what is the status of a refugee, or what is the status of a person fleeing from a conflict zone to an enemy state?
I just had a question about classification of refugees.
Okay.
Which I think you answered.
Okay. Basically, the question is right, and the basis is the 1951 Geneva Conventions on Refugees. There you have the definitions. Basically, someone being persecuted or fleeing away from a conflict zone, and there is a second level of that, because on top of being defined as a refugee, and a person cannot be defined as a refugee within that person's own state. You have to leave the border, unless you are at the most internally displaced person, which is a more problematic, less protected type of protection under international law. However, even if you're not a refugee and you're in a state, let's say a rebel comes to Israel, and Syria claims that that person has committed war crimes, and that person would claim, I'm being persecuted, and definitely I will be executed if you return me. There's another obligation that will prevent Israel from sending it back, and that's the non-refoulement.
What?
Non-refoulement.
It's refoulement, just in French.
That's professional.
I learned the hard way.
It's,
I know,
I
I'm
know.
butchered, but it's easier to remember.
So under international law, and you will find it in the Refugee Convention, you will find that in the Convention Against Torture, you're not allowed to send a person to a state if he in the danger of being persecuted or being treated inhumanely or tortured or being executed, etc., in that state.
It's exactly what they claimed against Israel with the refugees or not that came to the Egyptian border when they were being held. We dealt with them the arms
Yes,
together.
but there it's a different case, because there's an armed conflict in Syria, and those people who are allegedly refugees, they ran away from war. And that puts Israel in a position of whether are you neutral to the conflict or not.
And in Syria, why is that different?
No, that's in Syria. I'm talking about Syria. There's an armed conflict in Syria, and the people crossing the border are part, I don't know if they're civilians,
Not seeking refugees.
yeah, and that puts Israel in a situation where giving them back to Syria or not giving them back to Syria might risk its neutrality status. I'm not that good with neutrality law, but there is a question of neutrality.
I really doubt if Israel should be considered neutral with regard to Syria, since at least formalistic, in a formalistic point of view, the armed conflict between Israel and Syria never ended.
Yeah.
And
So there's nothing neutral to.
and Israel is still attacking in Syria.
So arguing that we're
According to foreign.
I have a question about that subject. As far as I know, Israel is really bombing inside Syria. Is it considered as an act of self-defense, separated from the war inside Syria? Or is it like an act of intervention in the civil war?
Okay, so we're going back to.
Is there a separation between them?
So I think it brings us back to what I said in the introduction about the situation in Turkey, where you can look at Turkey as being involved in the conflict. You can also look at them as protecting the border and the situation that might not even be considered as an armed attack because it's just cross-border incursions. With regard to Israel, the situation was thickens. Because, as I said, it could be argued that we've never ended our conflict, so it's not even not a question of self-defense. The extreme point of view, I'm not sure if I hold that point of view, since I find it an extreme one, is that these attacks are part of that long-lasting conflict. I think that would be a bit extreme. I think the more mainstream point of view would be that Israel is just acting as an immediate act of self-defense, an immediate threat, in accordance to the right to self-defense in international law.
I don't know the official Israeli explanation of the strikes. I think there's no official acknowledgement of these strikes.
No one here.
No.
I think, according to what's being written on these strikes, is that the main aim is to prevent the transfer of weapons to the arms of Hezbollah. And in January, what I find interesting with the discussion, the UK Attorney General gave a speech on the view of the UK, the legal advisor to the Foreign Office, he's also the Attorney General, gave a speech on the parameters of imminence. When is a threat imminent for state? And he said, based on a publication of Daniel Bettler, who was once the legal advisor to the Foreign Ministry, the UK Foreign Ministry, and based on his parameters, he said there is a few things that need to be taken into account that are different to the traditional views on self-defense, and especially on the parameter of imminence. He said one factor that is very relevant is the capability to act later. If I don't act now, do I have the chance to strike? Number two, he said, how harmful is the actual threat? I mean, if a threat might be considered much more imminent according to his view, even though this goes into necessity, but this is how they claim it, if the threat is huge. And the third parameter is also the high evidence that the attack will place, and this you can look if there have been already attacks in the past. So they look at the past to kind of analyze the future. And I think when I look at the developments recently on self-defense and what the UK Attorney General is saying, that they really take this into account. In the US, I mean, they refer to it, they target in different countries and they call it, I think they call it targetable, necessary, and under self-defense. So they mix all kind of parameters that sound very well in different different rules. They take and they call it persons targetable under self-defense in different countries. So they don't classify on each conflict and say at which stage are we in this conflict. This person is a threat to the United States national security, and then he's being strike. So Israel doesn't maybe have the leeway to act like this. I would analyze it this way.
Is there anything in international law that would allow us to defend ourselves with this line of reasoning?
I think that, in my view, the customary law on self-defense has not developed so much as is to justify the UK approach to it, because we have other states that have not don't have enough state practice that will really be established on this question, and we also don't have judgments on this and so on. So I wouldn't say it's customary, and it's also not an Article 51, I think, of the UN Charter does not give such a wide interpretation of self-defense right now.
Having said that, which I actually completely agree with, if you look at the origin of the right to self-defense in international law, I'm assuming at least most of you in public international law, it's someone
What you started
just starting now. So if you went to the question of self-defense of states, you would go into the Caroline test. Situation of the SS Caroline. I'm not going to get into the full story, but that's the origin of somewhat qualifying what the terms of self-defense are under international law. And as been said, it's about imminent risk, proportionality, and necessity. Okay, so you don't have any other choice. The attack has to be proportional to the threat, and it has to be imminent, meaning that you don't have any alternatives. You can't move, take any other option to other than the use of force. And if we look at the factual situation that led to this qualification, it was actually a situation of no international conflict, a situation of state versus a rebel group somewhere in the American, British, Canadian, French situation in Northern America. And the situation was of state versus rebels. Being supported, non-supported, it's a question, but the situation was at least state versus a non-state group. Later on, we moved to Article 51 of the UN Charter, which is clearly interstate situation, state versus state. And there are claims that these two levels of self-defense, the customary one, going back to 1837, I want to say, yeah, 1837, and the 1945 version of the UN Charter are not at the same level. But the customary is a bit bigger, and the interstate is a bit narrower, and that difference could be within that perspective, and that's where the British version might find its way.
It's actually worth mentioning that the U.S. in several instances where the UN didn't accept their view of self-defense went back to the Carolina case and said, well, the UN isn't necessarily the body to decide. We're following customary.
So at least once I agree with them.
In the Millennium Report of the UN, it's interesting. So after the text in 9/11, this topic of self-defense in the US war on terror was very common, this discussion, I think. And there was also UN Security Council resolutions, and they tried to bring a wider interpretation into the report. I think it was published in 2005, the Global Summit report. But at the end of the day, it was rejected. So some of the academics argue states have not agreed on the US wider interpretation, because at the UN level, they couldn't find an agreement on this definition. And then the published report, we see it in the draft, and in the published and final report, this wide interpretation does not come up. But they say that this issue really has to be addressed, and there's a lot of there's a high need for clarification.
It was actually mentioned in the memo that Bush relied on when he went south, when he didn't get UN approval for the strike on the war on terrorism. So his lawyers were on his side.
I think also with what she used, one of the UN resolutions that said that there will be, I don't remember the exact wording, but there was a UN resolution about Iraq that said if they don't do whatever, there will be great consequences or something like that, and they used that, if I'm not mistaken, that was some of the legal.
They were trying to go into RGP, but that didn't really fit the case at hand. And it's always a question of whether the US was just trying to find some legal flag to stand on so they can do whatever they wanted, or did they actually think about it? That's a lot of philosophy.
Just like now.
What was the legal reasoning for it? Like, how did they explain the, like, Libya, the coalition invade Libya?
The coalition in Libya was under a Security Council resolution which said you're allowed to act as long as you don't occupy Libya. That was the rule, and then US led forces into the situation, and Russia went back and tried to find a way to find a reading of that resolution that says no, you're not allowed to use force, but it was very slim, and the main point was you're not allowed to occupy Libya. That was the
Libya didn't have boots on the ground. It was all airstrikes.
one is I would argue that just like in Kosovo, the zero casualty policy is also an issue.
Zero casualty caught in Kosovo is debatable.
Depends for who.
That's always the answer, though.
No, but in Kosovo, the zero casualty thing was also.
It was an American thing.
It was, but it was also, I haven't heard that version. When they looked at the war crimes, the UN prosecutor looked at war crimes committed, they looked at the case of the bridge. They said that the zero casualties is a valid policy, and if that's the case, then there was no crimes.
Sorry, did you explain for us?
Sorry, yeah, we're talking in code.
It's a zero casualty.
It was a very, very famous case that happened during the war in Yugoslavia. What happened was, I don't know how it started, but the US had intelligence and information that there was a very important bridge that the Milosevic forces were using to transfer supplies. It was using as a for military reasons as well. So they decided to bomb it. That's one of the examples that you give for military use of civil bridges, and when you teach laws of war. And they bombed it twice, one on the right side of the bridge and on the other on the left side of the bridge, and the pilots were flying in high altitude, and at the time there was a train, civilian passenger train on the bridge, and there was huge civilian casualties, thousands if I'm not.
If I'm not mistaken, they knew about the train only after the bomb.
They knew about these, yes. So
the
the issue
plane.
was that because they flew such high altitude, because of the zero casualty policy, which meant zero American soldiers injured or dead, they couldn't see that there was a train on the bridge at the time. And it was one of the cases that was investigated by a UN commission that looked into war crimes conducted by the allies at the time, and the prosecutor decided, as I said, that because the policy of zero casualty is a reasonable military policy, they had the right to fly at such high altitudes because they did have danger on the ground, rockets and things like that, and there was no intention of killing civilians, and there was no wrongdoing, and there was no war crimes.
Say something. Going back to Syria, and I just would be very interested in hearing your views on this. The way I see it is that the US, they gave different explanations for the strike after the chemical weapons use. I only remember two of them. I think one was the prohibition on the use of chemical weapons, the International Convention. One was the US legislation on the prohibition of the use of chemical weapons. There was a third one. And right away, on the same day, I think, or the same night the strike happened, the next day, then in the blog, I think it was opinion Juris, Marko Milanovic, kind of went by the book and he checked all the parameters and came to the very clear conclusion that this was an unlawful strike. I mean, Russia said it was a strike in flagrant violation of international law. But for me, as something like studying international law for years, it's very difficult because on the one hand, you have this reality of mass atrocities committed. On the other hand, you have international lawyers taking offense at such a strike with the very valid argument that there have been attacks before in Syria which were much worse in terms of casualties than the use of chemical weapons. So people say it's hypocritical of the Americans now to strike because there have been other attacks which have been much worse. I just want to remember that in Yugoslavia it was not a US attack, it was a NATO strike, a NATO US led, but it was a NATO operation, and also at the time without UN mandate. So I know that in Germany, this was the first time that Germany took part once again in armed conflict. And there was a big debate because some people said they went by the book and they said that this is a flagrant violation of international law, there is no UN mandate for the use of force. And others said that the spirit of the UN Charter has two messages and not only one. One of the messages, and this Joschka Fischer was then foreign minister, he said is no more war, no use of force. But the other message in 1945 was also no more Auschwitz. So never again mass atrocities being committed. And I think today, when I look at the blogs, and this is my view, and I want to hear your view, I think we focus so much on the no more war and the use of the prohibition of the use of force, but we kind of forgot the second parameter, no mass atrocities. And when we look at the last 20 years, starting in the 1930s and the 1990s in Rwanda, I think this hints to some kind of inability today from certain bodies to act, and here I see a gap that's very difficult for me to close.
I think that, just in my view, I think that the shift, the no more Auschwitz thing, really comes up with the responsibility to protect. And that's such a controversial issue. When can you actually go in for a humanitarian intervention? And when can you not? And I mean, leaving the really legal terms, it's often used according to, very blunt interests. So, for instance, it was used in Libya, but it wasn't used in Rwanda. It wasn't, so it was sort of an attachment. But I think that's why it's not widely used more, because I think most countries are afraid of the legal custom that will create that, 20 years from now will oblige them to intervene in cases that they don't really want to. So I think that's why it's sort of left to the side to be used when everybody's decided that intervention is of course they want to take, and they just need something to be used. But I think that German policy left one thing behind. You don't need UN authorization if you're going the route self-defense. Even if it's collective self-defense. The Charter doesn't say you always need Security Council resolution. It acknowledges the fact that sometimes you're not going to get it. I mean, think about when the UN was created, it was Cold War. They knew that most of the times they're not going to get Security Council resolution. And if you think about the wars in that time where they actually intervened, most of the times they didn't have UN resolution. Even the wars on this side, Britain and France, when they decided or didn't decide, or was calculating whether or not to join the Suez Canal crisis, they weren't thinking, oh wait, we have to rush to the Security Council and get a resolution. So it's very convenient for countries to get a UN resolution because it's a very strong legal background, but you don't need it.
But besides ISIL fighters coming to Europe, none of the European countries is really threatened by anything like Syria or any of these groups.
I mean, they've all had, I mean, you can say that, first of all, you can use collective self-defense, which has been used before. And you know what, if I really want to make the case, I'm going to say look at Paris, look at Brussels, look at and all the bombings that are going on, that's ISIS. If we really want to protect ourselves from ISIS, we have to go to fight them in their origin, which is Syria and those countries. But by the way, that's a saying that's a lot of lawyers that deal with counterterrorism. That's what they're saying. They're saying don't deal with these people through administrative, human rights-based international law when they're in your country. That's a different spectrum, and that's going to be harder. Use, IHL and go fight them in their origin because there is a conflict there, and you can use self-defense there. I haven't heard anybody, official, saying these things and using that as a reason to go and fight in Syria, but
what is the precedent for collective self-defense against, within a non-state, non-international conflict against the state?
Sorry?
Precedents for collective self-defense in a non-international conflict against the government for the non-state organization.
Except for the US with the war on terrorism, who just threw every phrase in the book to justify what they're doing.
But usually they do it against the government, they do it regardless of the government's...
regardless of the government's reaction, but it was against the non-state actor.
Yeah. Here it's the person against the government.
Against the government.
Maybe the Russian invasion.
That, but you can say, well, Assad is no longer a legitimate government.
Did anyone say that?
Yeah, I told you the rest of them.
They did in the UN when a lot of these people in the UN resigned and came into the revolution at the beginning. The countries were saying Assad is no longer legitimate. The beginning, and he had all these people resign. He had his ambassador resign, and they were getting people to say.
Since then, it was the regime. What is the Assad regime, not anymore?
Yeah, they were calling it the Assad regime, not the Syrian regime.
The government, before they called it the Syrian government.
I can't think of any presidents, but international law is where at sort of a crossroad where you have to think about. I think new interpretation, because a lot of these places are, you're beyond borders sort of thing.
But if we go into that line of thought, that we are in the crossroad of international law, it's actually answered most of the issues you raised. Why is it was the reasoning, you could argue, not all government agreed with the US try, but it was mostly experts who say that's a problem, and government actually, it could be worse. It was one strike. Actually, Assad said he's going to get rid of all the chemical guns, so maybe it wasn't that bad. It's interesting that the main discussion is today's experts, legal experts on the one hand, who most of them have the very strict formalistic view that that attack was illegal. You do have some blogs by others saying that protecting that and then providing and proving how illegal it was and why it was completely allowed. You do have these blogs, but eventually, in practice in the international law, where you're looking for development international law, is not by the blogs and not by experts. It's state practice, and state practice is also the reaction to. So when the US is attacking Syria for the use of chemical weapons, and most of the governments are quite quiet about it, you could jump on the saying that we are in a crossroad and this is an act that it might not be supported, but it's also not being objected that much.
I think it's also an interesting case in Syria because of the issue that you're not entirely sure whether Assad is still maybe the recognized government, as the word, seeing him as legal leader or whatever. Because sometimes you get countries saying, any solution to Syria will have to be, Assad. Some are saying, he's still the head of state. There's a lot of debate because of diplomatic issues. I'm not so sure the world will be as silent if this would have happened with even a failed state, but not such a failed state. I mean, if it was a state that you still had a recognized head of state, you still had some sort of governmental structure.
You could say just move the situation to a different geographical area, and then you would have a clear discussion.
No, I'm saying, that's what I'm saying. I'm saying if it was a more of a governmental issue, I'm not sure a lot of governments would be comfortable being as silent. I think the uniqueness of the Syrian case sort of leaves more questions than answers, and it remains to be seen which way the crossroad is going to go with the US attack on the chemical weapons.
Right, we still have two pizza there, so use that. Otherwise,
does Assad have an active role in Syria or not?
Parts of the territory.
Parts of the territory. I think it also, once again, depends on who you ask. And how do you measure effectiveness? Exactly.
If we look to the future, how do you see a regime replacement if he's captured or if he's alive, if he's in some other country as a
legal?
Well, like Saddam Hussein, you didn't have any effect really by him, but still you didn't have an effective government until he wasn't captured, or soon before he was captured, I think.
But Iraq was different, right? Iraq was occupied at the time.
Yes, but this is a different case. This is what makes it more difficult because you have, like, I think, a ruling vacuum.
So let's take
as far as 6 years.
What's the next?
What is the future?
To the legal aspect, because this is international affairs question more than
yes,
and it's internal Syria.
Legally, also, if Syria will fall, Syria will stay as this country and the regime will change, but other countries or entities can rise and say we want our piece of land, for example, the Kurdish people, and maybe even ISIS will say and declare more than the Assad state. But what is the legal precedence in armed conflict, the internal armed conflict, and the entities that will rise as follows?
I think one question that might raise in such case when Syria will be divided to factions and regions with different sovereignties, this is, I'm saying from an Israeli perspective, it might sound funny, but I think that's a question deserves a debate is who will claim the Golan? Like which part of Syria will be entitled to claim sovereignty on the Golan?
The Israeli Golan or the Syrian?
Yeah, the Israeli Golan, which they claim.
Also, it might be if there won't be no more Syria in one day. Will it be still a claim for the Israeli Golan to go back to
I
Syria?
think legally there's two issues here. So one, yes, you can look at former Yugoslavia. They've reached an agreement. They've divided themselves into 5 or 6 states.
It's still going on.
And you know, that's fine. You can have a country dissolve into different. I mean, legally, that's not. You have to agree on the borders.
Yugoslavia was a unification to begin with.
Okay, but you can claim the same thing with Syria, that you have, you know, Alawites and whatever, you know, the shifting of borders, if it's on an agreed upon basis, then you're okay.
I believe that there will come one
But again, but as was said here, that's an international relations issue. I think with the question of the Golan, the interesting thing will be if the shifting of borders into different countries occurs, okay, if they're gonna stay one country with somebody replacing Assad or Assad staying in place, then you just have a change of regime, same country. Legally, I think, correct me if I'm wrong, but I think legally everybody will say, well, they're a successor of the old regime, like, you know, in South America with the juntos or Chile or whatever. And then the issue of sovereignty over the Golan isn't raised because it's still Syria. If they change into different, you know, 5, 4, 3, whatever countries, can the country that's holding, I don't know, the Syrian Golan still claim that it also has a right of sovereignty to the Israeli Golan? So can they claim that them and only them are the successors of Syria with the land?
I don't think so, because you have the territory, it's not related to the territorial link to the territory.
No, I know, but you're gonna have one country out of the separation that says we're the ones.
Let's say,
I think all of
if
them.
we're using the equivalent to the Yugoslavia, let's say you had Serbia and you had Croatia and then all the others, and Serbia would equivalent to Serbia, and get into troubles here. That state would argue the Golan is ours.
Because I think as soon as you have more than one of these states claiming the Israeli Golan is ours, that strengthens Israel's position on this is a border dispute. You know,
Yeah, but
we're you know, it's ours until the border dispute is settled, and you know, it's not just us in Syria or us, Syria and Lebanon in different places, but it's not, you know, 3, 4, 5,
Would that
whatever.
end internationally? Would that end situation of occupation in the Golan? That would be an interesting point.
That's the interesting point, but it will definitely give Israel sort of the same, you know, we don't have a choice, or, you know, even if it is occupation, what do you want us to give it back to?
We had a similar scenario also after 67, right? Because when the Jordanians lost control of the West Bank, at some point later in 88 or whatever, they gave up their claim for the West Bank. And then the PLO said,
I wrote a paper on that, so I mean, I think we're diverting.
Yeah.
It's not as easy because
but also there you had two.
in one sentence, the Jordanian claimed that they gave up the sovereignty for the West Bank because they transferred it to the Palestinians. Because 2 days after the Jordanians, or not 2 days, but really soon after the Jordanians did this, the Al-Fatah He gave a speech which the Palestinians called, he established the state of Palestine in that area, that exact borderline.
So it could be something similar. The eastern part of Syria could give the mandate of claiming the Golan to the western, now Republic of Syria that is...
yeah, but they'll have to solve it internally before...
Palestine, there was never a Palestinian state to begin with, that will argue that the West Bank.
Okay, so let's go back to
Syria. I want to say just one sentence because you asked how would be the developments, and I wanted to just raise one point which I thought about. And when I looked at the US strike, the multilateral conventions that prohibit the use of certain weapons, on the one hand, if you look now, maybe I'm going to leave philosophy, but it's on the one hand multilateral treaties, but it's also bilateral treaties. It's a treaty with one and every state. The US has it with all the signing states and vice versa. If I look at it that way, and then you can say if one of these states is violating that convention, one of them is the guardian for the others to act. And of course, I'm leaning here very wide out the window, and there's no precedence for that. But let's say there's a few crimes which the states, the international community considers the worst. These are, let's say, genocide, crimes against humanity. With war crimes, it's more complicated, but let's even say war crimes. And when we have mass atrocities, one state is the guardian for the other states in these multilateral treaties to act, to retaliate this violation of the agreement. But it's like an agency.
But every one of these conventions, even you have this kind of clauses also in the Geneva Conventions of universal jurisdiction. But all of these provisions are provisions of legal implications, and I mean you could pay compensations, you could be brought to the ICJ, you could be in violation. I don't think the chemical anyone is
no, but
the ICC.
You can bring a person to the ICJ.
No, you can bring the state.
Oh, the state, okay.
You can bring the state to the ICJ, but none of these treaties, bilateral, multilateral, provide you the authority to use force.
But let's say I have an assembly of all the states that signed the prohibition on the use of chemical weapons, and I do a vote. There was a prohibition. Syria used chemical weapons. Who wants the US strikes? And let's say I have a big majority of states. I know this doesn't just use of force. I'm saying that. Let's just imagine the scenario. They all raise their hands and say, okay, this was unacceptable.
You can claim
one of
that's
them
why
is
they didn't object.
Huh? Exactly. And I imagine this scenario. I think all the states are sitting there, or most of the signing states, not the, Russia, of course, sitting there and saying, wow, this was a violation of this convention that we agreed upon. I'm very happy with the US acted. It acted in my name also. And this is kind of a guardian principle or an agency principle, which there's no, I'm saying again, there's no precedence for it. But I think, it's not the legalata, but in the future, the legal finder is something that could be established.
I think it would be a more conventional issue or claim if the strike had more of a relationship or strings attached to the actual chemical strike. Because my problem with the issue, I feel it was sort of a opportunity seeking. Because what if they strike, they hit an airport that was up and running the next day. So, it seemed to me like a very flimsy legal argument for just show of muscles. They were just looking for the opportunity.
Question?
Well, I was going to say, so what you're actually suggesting is a way to bypass the Security Council. I mean, if you're looking
in the cases of mass atrocities,
right?
I think, for example, let's take the Genocide Convention. Sorry. There must be some kind of mechanism when the genocide occurs for the signatory states of the Genocide Convention to use force outside of the Security Council, because they are the signatories of the
So why do you need the convention for that?
because I have more states, and I can point to the violation very concretely, and I can have an assembly of these states. And
But you don't want the assembly. You want to
assume there's an assembly.
I'm saying it now, but I imagine it. I'm assuming the assembly to make a case. But in practice, I could also call for an assembly. I call all the member states of the Genocide Convention.
So what about calling a General Assembly resolution authorizing a strike?
Or I'll give you this. Take, for instance, another, I'm not wishing this, but the situation that was in Rwanda, okay, where UN mission soldiers, okay, refrained from using force because they were unauthorized, although they did know mass atrocities were going on and they could have used force to prevent it. So next time this happens, you're basically giving the boots on the ground permission to use force if mass atrocities is happening.
No, I'm giving the signatory states to international conventions prohibiting mass atrocities or the use of unconventional weapons, let's say, some kind of mechanism for the future, practical mechanism to retaliate or punish, if you want, by the use of force, the violation of the convention.
Okay, but you're saying that the actual use of force, because it has to happen so fast, like you can't actually convene the assembly. So you're giving an agent, whether it's a state or could be the UN mission head in that area, the UN forces, the authority to act as the agent of the signatory states and to use force when he can say Article X of the Genocide Convention is being violated. Article Y of the Chemical CW.
I think I would not give the authority to these UN humanitarian troops because they don't have the capabilities today. So even when the UN acts today under Chapter 7, it gives the mandate usually to NATO or to the United States or some other body.
Fine, it's NATO.
So who's going to overlook that agent? Or that state that decides that, well, mass atrocities are taking place. Chemical weapons is quite, not necessarily, even now Russia and Assad are claiming that we didn't do it, it was someone else. So chemical weapons is quite clear cut. Genocide, crimes against humanity, mass atrocities are very vague. And it's not that easy to say, well, this is the line. This is the line that if you crossed it.
I agree, but the problem is you can do terrible crimes to a few people and you can do minor crimes to a large amount of people. So looking at the casualties is not a fair measure.
Are you prepared to give one agent, NATO, one country, the authority to decide, or, in these cases it's the entire world, when these atrocities are committed?
This is exactly more or less what happened in Yugoslavia. A few states at the time, by the way, Russia was strictly against the strike in Yugoslavia because Yugoslavia was an ally. And with Russia, all the Eastern European countries, I think even Czech Republic at the time, all these countries, they were in outrage that France, UK, Germany, US struck in Belgrade. And after this, there was all kind of legal investigations of these, but it's very difficult when you have a few conventions that are aiming at leaving certain crimes not unpunished today, but at the same time, there's no effective mechanism to retaliate if the violation happens immediately. And
that's international law 101. International law doesn't have a police force to enforce international law.
But my question is, can the body, the convention body, the Assembly of States, can they give the authority to someone to use power? Do they have the authority to allow me to use force? Because as far as I'm concerned, the only body that has the ability to allow someone to use force is the UN. That's basically the security.
We're getting locked on that idea, I think, too much. And although it's an interesting concept, clearly we're not there yet. Was discussing and developing that idea, but there are issues that could be interesting for addressing. And you actually raised that relevant point of why cumulative guys and not other atrocities that were addressed. Before I move on to the points that were raised,
sorry, because it's going back to what he said, we sort of wanted to move on, but I just had a question. Or one of the questions, are you talking about in retrospect about treaties that are already signed? And if not, if you're talking about future treaties then which you would arrange differently, don't you think it would be a very big detriment? I mean, signing states wouldn't want their future activity to be limited, and maybe also the signatory, the state in charge wouldn't want to be obligated to intervene. So then you would have which countries would be willing to sign such a treaty?
Yeah, but you could look at also the opposite, because I think maybe because states in a sense, because they actually know that the treaty would be enforced. But I would do it for past treaties, I think, and also I haven't really thought it out to the very end. I'm just now thinking about the scenario. If I imagine this kind of assembly of the Chemical Weapons Convention, if all the states, let's say all the states raise their hand and say this was illegal retaliation, in my view, then the retaliation, the strike was legal.
Okay, let's end with one concept on that issue, is that I think the entire discussion would be either legitimate or lose its legitimacy if that question actually was raised by the drafters of the convention. If that was on the table when they drafted and said, we don't want use of force as a retaliation, but we want only interstate discussion of violation, then you cannot say, well, now we can't do it. And that has to be part of the discussion in order to make such an extreme change in a treaty, at least under current international law.
It's not the use of force, but you have this right, I think in the ICC statute, that when there is an arrest warrant by the ICC issued, there's a responsibility by state parties to the ICC to arrest that person, which if you look back at international law 101, how you call it, this was a flagrant violation of the state's sovereignty. You arresting my army general because I'm a member state of the ICC in some other country while he's at the airport?
I think there was the Kenyan guy, and then there was...
It wasn't a Kenyan, it was al-Bashir in South Africa. Sorry,
I was racist. But there was that exact case where there was an ICC issue arrest warrant. They said, it's nice of you, your warrant is very nice.
Yeah, it's not being enforced, but if al-Bashir was to come to Israel, not Israel, let's say Germany is a state country, the ICC, Germany would be under an obligation to enforce the arrest warrant. And this is also where I take the idea from. It's not a use of force, it's very, very far away from that. But
again, we're asking about, I think this is one more practical step of universal jurisdiction clauses rather than finding a completely new concept in international law.
Right.
Any comments on that thing? Because I think another point of discussion that could be interesting is how the ICC can take care of either the Syrian attack or the American attack. And we don't have that much discussion. And the reason we don't have a lot of discussion on the ICC applicability and relevancy to that situation is because neither Syria nor US are state parties to the Rome Statute. And under these circumstances, the only way that either US forces or Assad, assuming that the US forces commit the war crime, because you're saying it's a civil airport, it couldn't be. It's a civil airport or military airport?
military airport that was up and
I think
running.
there's no question.
Yeah, it was.
There was no civilian casualties.
But there's no
It was
question.
actually-
Syria
yeah,
has
Definitely
been
no
occupied.
civilian casualties.
And they gave it transforming and everything. It was
Well,
very by the book attack on this situation. But if
They-
you look
they
at
really
Syria and the
sure
chemical
is.
weapons, since Syria is not a state party to the Rome Statute, the only way to get the people responsible for the chemical attack under criminal proceeding in the ICC, the International Criminal Court, is if the Security Council provides authority to the ICC, to the prosecution and the ICC itself, and for that you need Russia not to object. So,
and also you have to remember that the US doesn't like giving.
The US
well, they gave in Libya, and the US have a very, that's one of my favorite parts of ICC and Security Council. The two times that Security Council gave jurisdiction to the ICC, despite the fact that the state is not party to the Rome Statute, they provided a small caveat, saying that the ICC has jurisdiction over that situation, over the people from that state, and every other person from the state party to the ICC. Meaning?
Not the US.
Yeah.
No, but I think an ICC case would be interesting if you look at the foreign fighters issue. And that might be a legal precedent to look at, and they were saying that they're already looking at it.
Yeah.
Because you have a lot of, you have so many people from countries that are actually signatory to the ICC. So, I mean, actually that was, I saw somebody stating that when there's a UK petition to revoke Assad's British citizenship. Because they're saying she's part of the whole thing, and somebody was saying, but wait, if she's a citizen, maybe we can try her, or it's a nice concept. Obviously, not somebody who wasn't a lawyer, but the whole issue of citizenship may be an interesting way for the ICC to do something with.
The thing is that the ICC is usually being looked at as meant to catch the big fish.
Yeah.
And not to use technicalities to get into a situation, because that.
But they have actually looked at it. I mean, there was a statement by this prosecutor.
Looking at it, something that's right.
Yeah, but
she came to the
I think
conclusion.
it shows how much, she feels like she has to sort of
She
get
also
there,
looked
and
into
then
ICC,
she's
yeah.
helpless,
But her bottom line was that she can't touch ISIS at the moment because no state in that area is party to the Rome Statute, and therefore no jurisdiction other than the technicalities. And I think she doesn't want to get into such big chaos through technicalities. What other questions about the comments about questions about why did the US respond and why did they respond now, why not before, right? It was part of the situation, and I've seen a lot of discussion about the fact that the current administration is trying to make a point. The current administration is trying to show that they are stronger than the previous administration. But there are other claims that says that the previous administration has set a line, don't use chemical weapons. And when they did, they tried at first using diplomatic measures, leading to the agreement that says that Syria is going to destroy or get rid of all the chemical weapons in its possession.
But is there any legal difference between the two situations?
Right. And right now, we were in a situation where Syria has breached that agreement. And since you could look at this as one line, saying that the US were saying, we're gonna attack you unless you're going to destroy the weapons, the chemical weapons. And Syria said, okay, we're going to destroy the chemical weapons. A lot of discussion whether or not it's a good agreement or a bad agreement, but a couple of years later, we are here, and apparently they either didn't destroy all the chemical weapons, or I don't think they manufacture new ones because they were really easy, but they use chemical weapons, and then you could look at it as saying that the US were saying, well, we gave you a warning, we tried diplomatic measures, now we're at the point of there are no alternatives, so we are using force. The question is whether or not they were in a position to allow themselves to use that force legally. And one question I was thinking about was, what if someone else related to the situation would have asked? I mean, to look at the US as arguing self-defense from the chemical weapons is a bit far-fetched. But to look at, say, Israel would say, well, that chemical weapons is a threat to us, is a strong threat to us. It could get thrown at us, get rocket towards Israel anytime. It's an immediate threat. We have a right of self-defense against that, against the use of chemical weapons. And we're asking the US to help us. So, do you think that would change your point of view on the situation if it wasn't the US acting on its own, but acting at the request of Israel, for that matter, or Turkey, or Lebanon, or Jordan, or Egypt, or Iraq, or I'm on the east side, I'm losing my borders. But do we need to know about such a request? Is there any, I think, if Israel is in position that they are asking the US to help, do you think that should be allowed? Is that would be a legal requirement? Would that be even more requirement? Because we want to know that the US is actually helping someone else and not itself at the moment, and has some grounds to get attacked. Here we don't have any information that this was the situation. It's a theoretical.
But then, if let's say there were casualties within the American attack that were a lot worse than what they were. Let's say there were civilian casualties. Let's say there were secondary explosions. I don't know that they're just a lot worse than it actually was. And let's say that they were acting on behalf of Israel or Turkey or whoever, would the US diplomatically want to take
like agree to the responsibility?
Yeah, to take responsibility, and also for, it's a question of state responsibility, because you could if that were the case, then you could easily tie Israel to have responsibility for the casualties that were created there. Then the question is, if it were under the radar, if the Americans would take credit or have to deal with the international and local implications of having a much more serious
damage?
Yeah. A much worse side, end of the day. Like many people are killed, whatever, would they take that credit? Or would they deal with that?
I think,
Because I'm not sure if they would.
I think diplomatically is not the scope, but I think that your question about do we need to know as the public just stems from the fact that you live in an information free-for-all era. If this had been 70s, 60s, I'm sure there were a lot of things that happened with country did X and requested somebody else, and then you have security relations, and not everything is this.
Yeah,
so you knowing, for me, is not a legal requirement. You as an international community.
Yeah.
Okay. Is it a, so for me, with the international requirement, it's suffice to say the US are saying we did it under self-defense. Because for me as a legal expert, self-defense is wider. And it can be collective, there's different ways of doing it. Is it a legal requirement for the lawyers authorizing it within the actual need to know basis community within the US? No, like our take the Israeli case. The army lawyers in Israel that authorize a strike, they need to know it as part of a legal issue? I think so, because I think it's part of the legal consideration. And with regards to the other question of the damage, the fact that Israel asked the US to do this, and the damage was not proportionate versus, doesn't necessarily say Israel's responsible. Because you didn't, as long as you didn't tell them exactly what to do and plan the attack for them, even then, I think they have the responsibility to legally check it out with regards to proportionalities and support. I think it's at the end, it's the person who's doing the strike, because you're always emphasizing that proportionality is something that is not decided by a lawyer. It's decided by the field commander under the situations that he's within. So you never go back and check it. It's his responsibility. So it would be the US case.
That's in the Israeli manual. I think that the field commander takes to look at his assessment. I think not all the manuals, except only the field commander's assessment. It's the Israeli manual that says that the field commander on the ground. I think there are other manuals that see it differently.
Well, no, but again, even if you say, okay, it's not the field commander, it's the lawyers behind it, which is, you are looking at it, but you're always looking at it from the fog of war situation. And it's, so it can't be Israeli responsibility because we suggested, even if we suggested the target. So, a sort of example, I don't know if you've seen The Eye in the Sky.
Yeah.
There's a discussion there, almost an argument, because the UK won't strike and the US is saying, well, we authorize you to strike. Okay, but and it's becoming worse because the drone is a US drone, but it's being used by the UK. But
But so how do you explain, tests like the damage tests that are much more, I mean, specifically they're talking about obviously responsibility in regards to, a non-state, a non-state.
Justification of conflict.
It wasn't specifically on the
okay, I see what you're saying, but I still do think that it would be obviously convenient for Israel to say that, they were the last one, the fog of war won on, and then it was on the Americans to have final discretion in whether to
Well, the US is acting under fog of war situation, but they also have the obligation to check it themselves.
Sure, I'm saying it's convenient for Israel to say that, but it seems also a bit naive. And especially considering Israel's international.
Well, it depends on, if you look at state responsibility rules, it's a question of how much information did Israel have and how much information did Israel provide specifically to the operation. So if Israel had told the US, we want you to strike here, and even the US are going to say, well, okay, we're going to use these kind of weapons, and Israel would provide the information on the ground.
Yeah, so all the intelligence was provided by Israel.
That would be something for one thing.
It happened in the Windows case when Germany struck, NATO struck, and Germany gave the pictures, and the assessment was totally wrong, and there's 130 civilians dead.
And even then, it wasn't much of a, it was held that it wasn't disproportionate.
Yes. Because from the information available, it seemed at the time, it seemed that it really was looking fighters. there was exactly, I think there was a NATO kind of AWACS airplane, which gave all the pictures. And at the end of the day, was a German commander within the NATO mandate who gave the green light, but there was different military equipment used in different countries to operate the strike, so it became very complicated.
Sure. I'm assuming you're not familiar with the Kunduz situation, so can I let the German explain that?
It was a strike in Afghanistan against a truck, and it looked from these pictures and from the information available at the time, it looked like a transfer of a few rockets, I think.
I think it was fuel.
Yeah, fuel, and it looked also there was a large group of fighters gathering around this transfer. But at the end of the day, the fighters happened to be, I think most of them, to be civilians, and they were not participating in hostilities. It was just a mistake. And Germany also took responsibility for that mistake. They paid compensation to families of these victims in court, but at the same time, there was no individual criminal responsibility for the German general that authorized this. Because ex ante, from the situation, it was let's say a mistake that could have been made.
Any other questions, comments?
I have one. Might be a little bit controversial thing. In my opinion,
I think we've passed that.
There are three things that bother me most about the American strike after the chemical assault in Syria. The first thing is shouldn't be the claims of the Assad regime, the Russian claims that the chemical attack wasn't made by Assad regime or other forces that allies with him, and maybe it was, I don't know, false flag or some kind of other thing, maybe it was staged, I don't know. The second thing, shouldn't there be any inquiry before the strike, because the strike happened to be really soon after the attacks. Should be at least something, maybe not investigation, because after this you will have a long time. If you will have an investigation, it will take a long time after the retaliation. And some sort of inquiry to check those claims, because I don't think there was any self-defense, because we didn't see any other chemical attacks happening soon. So especially the attack was on an air base, which is not related to any chemical attacks. And the third thing, which is related to the first thing, you can say that it feels to me that all the move that was acted, especially by the Tomahawk attacks soon after the chemical attacks, was mostly emotional and not, of course, legal, and of course, after serious thinking and inquiring, was it happening or not?
Okay, so I think a significant part of your questions is related to the discussion we had about the right to know of the general public with regard to what the intelligence know. Because if the American intelligence or any other states, in this case the American intelligence, have enough information that this was a Syrian government attack, they have more chemical weapons, and that location is both strategically and legally relevant, then that there is no need to wait for any commission of inquiry.
If that was the case, of course, but
Yeah, but
this seems a little bit different.
is there any chance that they will attack without any kind of evidence?
There's a chance, yes. Whether or not it happened, well, a lot of questions about violations, whether or not violations took place during the course of a conflict, is a question of examination. Usually post-conflict examination, but that's definitely ex post facto examination. And this is a question of how do you evaluate, how do you do inquiries about what took place during non-conflict. And there is no way that I can think of to do it immediately after attack one before you did the retaliation. The retaliation, whether or not it was legal, will have to be examined later on. And we do see these kind of examinations by the UN, the Human Rights Council on the one hand. The Secretary General has his own commission of inquiry from time to time, and especially internal ones. You can see in Israel there are a lot of examinations and processes, both administratively to avoid future mistakes, but also in the criminal course to see if any crimes were committed. But as in any other mechanism of review, it can't be that immediate, but it should be taken later on. There should be an examination whether or not the American reaction was legitimate or not. And it could be internal within the US Army, it could be internal within by the House of Representatives, or it could be within the international community. Any one of them could be sufficient and could be seen as legitimate. And it depends on whether or not the examination is real, legitimate, independent, and so on.
I don't think, coming to your question, that the US would be under some kind of obligation to provide the international community with their evidence, let's say filming the strike. We have a certain problem now with the facts, because the US says that they have clear evidence these were planes taken off by Assad, and then you have Russia saying this was a rebel storage factory of chemical weapons which was attacked, blew up. We have this in Israel. I mean, it's unfortunately experts to this. We have these YouTube investigations that kind of lead a lot of decision making. I think both to attack and also not to attack in certain points. I think conflicts have these moments, trigger moments, when certain videos go viral. That's why I'm saying it's very problematic, because apparently the international community takes it, or the public takes it harder when there are babies seen that have been attacked with chemical weapons, than another attack which hasn't been filmed, where there are higher casualties, and so on. So I don't think there would be an obligation. It would be very difficult, I think, for any military to really conduct the fighting if they had to provide the evidence.
This is the advantage of an internal examination.
Yes.
By the US forces or by the US Congress or whatever. That would be the advantage of having that internally, because then they would be in an obligation to provide material. There is no obligation to provide that in the international environment. I had no intention to imply that, but the fact that you don't have an obligation doesn't mean that the international community is not allowed or is unable to conduct its own inquiry.
I think the Israeli system of the fact-finding mechanism is a fantastic.
Fact-finding is Israeli?
No.
You mean the fact-finding, the Goldstone fact-finding?
Not Goldstone. Israel has after the Turkey Commission, they established a fact-finding mechanism to investigate alleged violations of the laws of armed conflict and the military. Okay. So I think this is very developed, much more developed than other states. What I want to ask you too, I don't know, is there some kind of monitoring body or steering committee about the convention that prohibits use of chemical weapons, like we have with the Convention Against Torture, where the states give reports and then they can say, okay, we think that on when was it now, March X, there was chemical weapons used in Syria and so on. Is there something like this, or this is one convention, but it's like a dead convention? There's no reports on that.
Well, first of all, there is somebody who's monitoring, because the UN has just published a report today or yesterday saying that Belgium was chemical weapons like Syrian, and somebody was looking into it by the UN. I think it was there is some sort of body like the IHL for nuclear. I'm not sure if they're directly related to the convention.
We have the special rapporteurs on different issues that definitely have the authority to look into these issues.
But they were looking into it. But I think with your question regarding to the fact that it was an airport, I'm sort of trying to look at it from the U.S. point of view. So the non-legal claims were sort of, yeah, they violated the agreement, so we striked. This was just sort of a warning strike to show us that we're not messing around. And that way, this didn't have to be directly related to bombing his chemical facilities or whatnot. And I think that's an interesting thing to look at because the strike has to be related to a military objective. If it's, now there's no U.S. fighting going on in Syria on a conflict-based, day-to-day thing. So what was the military objective of striking that specific? I mean, maybe they have intelligence, which I don't know, fair enough. But if it was unrelated, as the media is saying, that was just a military airfield.
I think they said that this is the airbase where the bomb departed to the.
Is that
I think that's
good enough military objective? I don't know.
It links.
It links, but international doesn't require a linkage.
Do you need a good enough military objective? It's a
Objective?
military objective. It's a military objective if it's part of a non-conflict.
Yeah, but
Don't
the
need
fact
to
that the U.S.
quantify them.
isn't, but the fact is that the U.S. isn't part of the conflict, which makes sense. So if the rebels were involving these military objectives and they're part of the conflict, I have a problem.
I think that there are two bodies of law that governs legally this strike. It's both USAC and INBEL, because INBEL I don't think requires like some sort of linkage. Correct me if I'm wrong, but INBEL probably does require some linkage between I don't know if it's self-defense.
Under IHL, the attack has to be effective to stop the threat.
To stop the threat.
So even if that was the airbase that the planes were coming from, the U.S. could have struck anywhere else, assuming that the attack under IHL is effective to that point. It's not disproportionate, it's not too much power, it's not too much force to that measure. Clearly, by making the link, you provide more legitimacy to that attack. But legally, I'm not sure that.
I still don't see how the US
if you're in
can
IHL and
establish
it is effective to stop the strike, show muscles, show force, saying don't mess with us, this is your warning. I'm fine with that argument. That's what I was saying. I'm trying to find the proper legal argument. So the U.S. and Syria is a rebel case, even though it's a conflict. And the retaliation, the act that brought on the retaliation is part of the armed conflict.
This question is still, we're still in the blank here.
Yeah.
We still need more information, and it could be that it was the first try into U.S. involvement in the Syrian conflict. It still could be.
Did the US already strike in Syria, or did they strike before? Just not provide some kind of.
Not that I know of.
I'm not sure. They strike in Syria with regard to specifically on ISIS. but not with regard to the conflict, neither against Assad.
Okay, but that doesn't.
No, but they
Once
didn't,
they
they
invaded
didn't,
Syria,
they
sovereignty, it
didn't,
doesn't matter.
they didn't use, the legal argument was this is the war on terrorism, it's not necessarily conflict. We're not.
That's part of the usual US policy of we are attacking terrorists all over. Unlike this attack, which is against the government.
Yeah, but from a legal perspective, you look more at the strike. I don't think you look at the.
Well, Israel has an ongoing policy of we're attacking Afghanistan, we're attacking Pakistan,
US.
we're attacking US.
Israel hasn't struck.
That we know.
Yes.
But the US has the ongoing policy of we will strike wherever it's within the general counter-terrorism, the war against terror. And this is even if it happens within Syria, it's not an attack against Syria according to US perspective.
Yeah, but I think there is.
I think that the presence of these people, I think in their view, justifies that ongoing strikes. I mean, once they say, once you have certain group of people, it doesn't matter which territory they are, which are threats to US national security, they use it.
I think there is an SLC, the new commentaries to the Fourth Geneva Convention. I think that the new commentary to Article 1 was that attacks on on states not related, like non-international armed conflicts, if you attack on a rationale of how is it called, unwilling and unable, that could initiate an international armed conflict between the attacker to the attack. But I'm not entirely into it. Maybe I'm not.
Well, I can tell you one thing, that not happy, but I know quite a lot of law professors who are now frantically writing their exams for the end of the year with all these, questions. He's one of you got some new materials.
Okay, unless there is.
What is there? What was I want to ask?
Yeah.
The people that write in the blogs.
Yeah.
So what is their response when they only come out when there has been a strike against the use of chemical weapons? What would they say if I asked Marko Milanovic? You see that, I don't know, 400, 500,000 people are being killed. What is your response? What would you
legally or morally? As morally as a person, I'm sure he's actually a nice person.
No, he's a great person.
But especially if he's watching. But he's trying to make the dry legal analysis of the situation as a legal expert. And clearly, that's his role, and that's the role of any legal expert of international law to think about what is the situation, and some will try to push it towards the legitimacy of the attack, and some will push it towards the non-legitimacy of the airstrike. To argue that, what does he think? As a person, he could think that is the one thing, and the attack was justified, but you would say legally it was illegal. And you do have a mechanism for that, even in criminal law, of justification and excuses of, or maybe it was illegal, but we should allow it. So it could go either way. Yeah, that's good to wrap it up. So thank you very much for coming. Thank you very much for eating most of the pizza. And we look forward to see you in other events of ALMA. And we are trying to develop the notion of these open discussions. So if you actually have an idea of a topic you want to hear such a discussion on, please let us know, and we'll be happy to provide the platform and have that discussion with more pieces. So thank you for coming.
Thank you very much.